right, I will call this meeting of the Senate Judiciary Committee to order. Will the Secretary please call the roll?
Senator Flores, Senator Orenshaw, Senator Lang, Senator Wynn, Senator Hansen, Senator Krasner, Senator Ellison, Chair Scheibel.
Here, thank you so much. Please mark Senator Hansen present when he arrives. And today we have 3 bills up for a hearing. They are all going to be presented by the Supreme Court or the Administrative Office of the courts. So unless there's a reason not to take them in order, I'm just going to take them in numerical order. Okay, perfect. So that means that we will start with SB 13, and I invite the presenters down to the front now. I know you've been here before, but there's a button on the surface of the desk. You're giving me a thumbs up. You know how this works. Please go ahead whenever you're ready.
Thank you, Chair. My name is John McCormick, John, last name McCormick, McCormick. I'm the Assistant Court Administrator at the Administrative Office of the Courts. The first bill we have for you today is Senate Bill 13. And, and there's an amendment that we provided on Senate Bill 13, which is sort of what I'll be presenting off of. There was some confusion in drafting as to where the sentence got placed. So the amendment that has been provided is to return it to the original intent. Basically what this bill does is it allows the defense and prosecution in a criminal matter to stipulate to a disposition of bail different than exoneration. So basically, it is sort of an efficiency measure to facilitate plea negotiations. For example, a lot of times in a negotiation, they will get to where the bail will be used to potentially pay restitution or some other monetary penalty with the offense as a result of the plea agreement. So this allows that bail to be stipulated and used for that purpose rather than exonerated back to the payee. So it is intended as a sort of a measure to facilitate plea negotiations and to hopefully increase efficiency rather, excuse me, on those. And the reason again for the amendment is to move the provision that allows that stipulation up to before bail is exonerated to facilitate the negotiations or the other disposition. So that is Senate Bill 13 in a nutshell. I was going to jinx myself and say hopefully it's a simple bill, but you know, I was going to, but I did anyway. Sorry about that. So I will stand for questions. Thank you.
Are there any questions from members of the committee? All right. I'm not seeing any questions. So I have, just to clarify, you're not intending to expand or restrict the things that bail are used for now? Because I know sometimes bail is already put towards restitution or a fine payment, so you're just putting into statute that that is an allowable use of the bail.
Thank you, Chair. John McCormick, for the record. That is exactly the intent, and also to stipulate before it's exonerated, so the court doesn't have to exonerate it before that use happens. So this allows that pre-exoneration stipulation.
That makes a lot of sense. Thank you. All right, not seeing any other questions. We will move to testimony in support of SB 13. Anybody wishing to give support testimony is invited to the front of the room here in Carson City or down south in Las Vegas now. I don't see anybody coming. Oh wait, I don't see anybody coming down to the floor, just people changing seats within the audience. And so we'll go to the phones for support testimony on SB 13.
Thank you, Chair. The public lines are open and working. However, there are no callers to provide support testimony at this time.
All right, we will move to opposition testimony on SB 13. Anybody wishing to give opposition testimony is invited down to the front rows in Carson City and Las Vegas now, but not seeing anybody, we will go to the phone lines for opposition testimony on SB 13.
Thank you, Chair. There are no callers to provide opposition testimony at this time.
All right, we'll move to neutral testimony. Anybody wishing to give neutral testimony is invited to do so now. And I don't see anybody coming up in person in Carson City or Las Vegas, so we'll go to the phones in case anyone's joined us for neutral testimony on SB 13.
Thank you, Chair. There are no callers to provide neutral testimony at this time.
All right, then that brings us to the conclusion of testimony and the conclusion of our hearing on this bill. Mr. McCormick, you now have the record for fastest heard bill in Senate Judiciary of the 83rd legislative session, possibly in all committees. And with that, we'll close the hearing on SB 13. We will open the hearing on SB 17 and invite those presenters down to the table in the front. I know some of you are very experienced in testifying in legislature, but you haven't seen our fancy new microphones yet. And the buttons look like a sticker that was just dropped on the table. You press that, it turns red. Red does not mean stop. Red means go, or it means the mic is hot. They're the same thing. And so now, go ahead whenever you're ready.
Good afternoon, Chair Scheibel, members of the Senate Judiciary. For the record, my name is Kendra Birchie, and I am a Justice of the Peace in Reno Justice Court. I am so excited to be here before so many familiar faces. Today I'm here to introduce Senate Bill 17, which introduces targeted small improvements to our existing specialty court statutes, creating a significant and positive impact on the lives of our citizens. For those of you who do not know what specialty courts are, they're also referred to as therapeutic courts that use evidence-based practices, treatment, and case management to address the root causes of criminal behavior that includes substance use and mental health disorders. Across Nevada, there are approximately 64 specialty courts. Those courts range from focusing on mental health, substance use, competency, veterans issues, development, disabilities, women in need or trauma, youthful offenders, among other focuses. Based on extensive research, specialty courts are considered the most effective justice intervention for individuals who have substance use or mental health disorders. Through collaboration with treatment providers, law enforcement, intensive supervision, prosecution, defense, and the judiciary, these courts operate to provide continuous, individualized support that promotes lasting change. Some of the benefits for these treatment courts are that they reduce recidivism, so they make it less likely for individuals to commit another offense. They save taxpayers money, and they protect our communities. According to national standards, they reduce recidivism by as much as 58%. They also have saved taxpayers an average of $6,000 per person who is involved in a treatment court program, and they are known to break the cycles of addiction. The current law allows a criminal defendant to enter into a treatment court in several different ways: as pre-prosecution diversion, as diversion following a plea, or as a condition of probation. Diversion means that at the end of successfully completing one of our treatment court programs, the intensive programs that last a minimum of a year to up to 3 years, depending on they completed successfully that program, the individual receives that benefit of not having the conviction on their record. This further reduces a defendant's involvement in the criminal justice system and is a significant motivating factor to enact lasting change in a person's life. Section 1 of this bill modifies our current statute related to pre-prosecution diversion. Current law already allows and permits for pre-prosecution diversion when an individual has been charged with a misdemeanor. This bill modifies our current law to mirror the changes that were enacted by this legislative body through Assembly Bill 222 in the 2019 legislative session. This bill would only increase the amount of individuals who are eligible for consideration for pre-prosecution diversion. I want to make sure it's clear that this does not change our current practice in terms of the law with how somebody can enter into pre-prosecution diversion. The judge would make that determination based off of the information that's provided to them through the parties, the prosecution, the victim, if there's a victim in the case. So this does not make any modification for the procedure for pre-prosecution diversion, just for who is eligible. Nationally, the trends for different treatment courts have been to expand pre-prosecution diversion. Nationally, the trend is to actually allow for more felony offenses to be eligible. We are not doing that here. Again, the only way for someone to be eligible for pre-prosecution diversion if they are currently charged with a misdemeanor offense. Section 2 of this bill and the remaining sections make slight modifications to the statutes related to substance use courts. Section 2, Section 3, and Section 4 make modifications to clarify that the justice, municipal, or district courts can create those therapeutic courts addressing substance use. Last legislative session in 2023, this committee passed Assembly Bill 405, which modified the mental health court statutes to change a court to indicate what exactly those types of courts are. So this bill just makes the same correction for the substance use treatment courts. Section 2, subsection 2B makes a slight modification. And what this does is allow for the treatment courts to conditionally allow someone to enter into their courts to do the evaluations to determine whether or not they qualify. So for example, those are, it could be a psychosocial, a mental health evaluation, or a substance use evaluation, as well as determining whether or not they are high risk, high needs. So the evaluations needed to then determine whether or not they should be allowed to participate in that program. So that is the main modification in that section. Courts in our jurisdiction across Nevada just indicate that they would like to have that opportunity to be able to use our funding from the AOC, the Administrative Office of the Courts, to ensure that we have the right people into those core programs. And that is my presentation on this bill. Thank you.
Thank you so much. Wonderful to see you, Judge Birchie. And if there are any questions from the committee, Senator Ellison.
Thank you. I think you laid this out quite well. Question I've got, if they say they've got multiple charges, one that was drugs and one might be breaking and entering or whatever, theft. So how would you handle that? Because if there's multiple different types of courts, how does that work?
Thank you, Kendra Birchie, for the record. With your question, if I'm understanding it correctly, so if somebody is charged with multiple offenses, with the offenses that you've outlined, they are not eligible for pre-prosecution diversion because, for example, possession of a controlled substance is a felony, so they would not be eligible. So if they have multiple offenses and at least one of them is a gross misdemeanor or felony, then they are not eligible for pre-prosecution diversion.
I'm sorry, I should have said like marijuana charge or something like that, that it'd be more or less of a charge. And then another charge it'd be on top. So one would be something you could handle and one wouldn't be, is that correct? One is a felony or a gross misdemeanor, that wouldn't be allowed in there, but if they had a marijuana charge or something, how would you handle the two? Would you just say, okay, you're gonna have to handle that charge on another court? And this in here is a light charge, whatever it is, any kind of a light charge.
Thank you, Chair Scheibel, through you to Senator Ellison, Kendra Birchie for the record. So if there's one charging document that has that felony offense, the gross misdemeanor offense, and the misdemeanor offense, they would not be eligible for pre-prosecution diversion.
Okay, thank you.
Thank you.
Vice Chair Flores.
Thank you, Madam Chair, and thank you for the presentation. It's great seeing you. First, I'll start off with kind of a broader question. You indicated that there is a trend nationally to kind of cast a larger net. We're talking about gross misdemeanors and felonies. Do we have data on whether or not the programs have been successful there, where we're expanding and casting a much larger net? And then I'll come back to a direct question on a section here.
Chair Scheibel, through you to Senator Flores, Kendra Birchie for the record.
And you can go direct.
Thank you. Yes, and I can provide this information directly to the committee, but what I have been able to determine, and just this is specifically for pre-prosecution diversion for felonies, is what the studies have indicated that in Birmingham, it has reduced criminal recidivism by 18%, in Tacoma by 19%, in Jacksonville by 11%. So those are the data that have been studied since, I believe, I don't have the date on hand, but I believe it was from 2006 for some of those studies, and then the recidivism is based off of 3 years from that.
Thank you. Madam Chair, if I may ask a different question. Thank you for that. I'm curious to know, now that with this amendment, do we have any indication of how many more folk would be eligible now if the bill went into effect? How many more folk we think we would be considering for these type of programs?
Kendra Birchie, for the record, I do not have that information. Mostly because when we are looking at this as at arraignment, and as a judicial officer, we just don't have access to all the information as to what an individual has been charged with and previously convicted of. The current law indicates that if someone has been convicted of any offense other than a minor traffic violation, they are not eligible. So I can say that this would expand the ability for people to ask for pre-prosecution diversion, but I don't have the exact numbers, as that is not something that we have been able to monitor.
Understood. And Madam Chair, if I could have the privilege of one more question, thank you. I know sections 2 through 4 talk about allowing, justice court, municipal court, allowing them all to establish the program. I'm curious to know how in tangent, how closely do they work together now between one jurisdiction to the next, and how do these programs look like? Are they dramatically different? I'm just curious to know how that information is flowing and how we're establishing them between one and the other.
Thank you, Kendra Birchie, for the record. In Nevada, in order to be considered a therapeutic court, you have to adhere to the standard set by the administrative office of the courts. They are best practices that they have established. I believe that it is 10 factors that must be met by every court in order to be determined to be a therapeutic court. All of our therapeutic courts that are considered therapeutic courts by the AOC also follow by the All Rise standards, and All Rise had previously been NADCP, and I had it down somewhere with what it stood for. The National Association of Drug Court Professionals. So those standards, they do yearly trainings that the AOC does assist to make sure that judges, court staff, I know our office assists to make sure that our prosecution team, that our defense team, that our law enforcement team are able to go to those every year if possible. We also in Washoe County meet quarterly with the different therapeutic courts to talk about best practices, as well as to make sure that we are advancing and improving our treatment courts and in line with best practices nationally.
Perfect. Thank you.
Sure. Are there other questions from members who haven't asked a question yet? Okay, we'll go back to Senator Ellison. Go ahead.
You brought up a good question. You answered most of it. How many courts in the state of Nevada, the JPs that are actually doing this? And John, maybe you know that.
Thank you, John McCormick for the record. Currently, as Judge Birchie indicated, we have 64 specialty court programs established in the state. Off the top of my head, I don't remember the breakdown between district and limited jurisdiction, but as the judge indicated, they all have to comply with best practices. The 10 key components of a therapeutic court were promulgated by NADCP when it was NADCP before they changed their name, and they all have to follow that. And then we have extensive funding guidelines that they must comply with for that. The programs are working pretty well, and there's a lot of communication. I was at the first judicial district over here the other day, and we were discussing some specialty court stuff, and there's a lot of discussion about transferring participants between programs, which is a very common thing that, a defendant, say in Elko, receives an offense and is determined to be high risk, high need, and appropriate candidate for a mental health court, but maybe the services aren't in Elko, so they'll work out an agreement to transfer that defendant to a different court if they can make it to do that. So we're currently engaged in a lot of that sort of collaboration. We have regular discussions, meetings with our specialty court funding policy committee to discuss these topics and kind of identify areas for improvement or where we're looking at. We've expanded with peer review, so we have a number of initiatives going on to sort of tighten it up and improve our delivery of service.
Any other questions? Yes, Senator Orenshaw.
Thank you very much, Chair. I think a lot of us have learned that, substance abuse and road to recovery can be, 2 steps forward, 1 step back sometimes. And as I'm reading the bill, I just want to be sure I'm understanding it correctly, that someone could have successfully completed a diversion program, let's say a substance abuse program, and then be referred in the future, if this passes, to more treatment. Let's say it's substance abuse treatment. They wouldn't be precluded anymore from being able to participate in a diversion program, let's say for substance abuse?
Kendra Birchie, for the record, yes. And the reason for that is we based that language based off of the Assembly Bill 222. So in that bill, it modified the Veterans Court statutes related to who is eligible. There had previously been that preclusion where if you had been involved in a therapeutic court, you couldn't do it again. And since this legislative body had made that change, we adopted that language into this bill.
Thank you, Judge Birchie. Thank you, Chair.
Any other questions from members of the committee? Senator Krasner.
Thank you for your presentation. So since he asked that, now I just need to clarify. They would be allowed, but not if they were convicted of a crime of violence, a sexual offense, a crime of battery, which constitutes domestic violence, or vehicular manslaughter, correct?
Kendra Birchie, for the record. So yes, what is outlined in Section 1, subsection 4, including B, with if they have been previously convicted of a crime of violence, any crime of violence, any sexual offenses outlined in NRS 202.876, a crime of battery, which constitutes domestic violence, vehicular manslaughter, or driving while under the influence of liquor, intoxicating liquor, they would not be eligible to request for pre-prosecution diversion.
Any other questions from members of the committee? All right. I don't have any questions. I'll take a point of personal privilege, though, to say I can't say enough good things about diversionary programs and therapeutic courts, including our pre-prosecution diversion program. So being able to reach more people is always good, and also being able to develop more programs in more courts. I've certainly had clients who've transferred between programs. Something else that I do want to mention is that it sounds like Section 2 is going to allow more courts to stand up these programs. And for some people, it's really important that the program they participate in is centered in their own community. Some people are very successful. They go somewhere else and they complete a diversion program. I've seen people who fail their therapeutic programs because they were not home-based, and then as soon as the court that they were originally charged in opens up their own program, they're able to successfully complete that one, notwithstanding the issues of being eligible for it, having already participated in one, which is absolutely a barrier. So anyway, I think that we have a lot of good things in here. And with that, I will invite anybody anybody who is here to give in-person testimony in support of SB 17 down to the front now to do so. You can just take a seat here at the witness table, turn on the microphone when you get down here, give the spelling of your name and your comments. Please limit them to about 2 minutes. Thank you.
Good afternoon. My name is Esther Quillici, Esterquillici. Thank you, Madam Chair and members of the committee, for hearing my testimony. I have served as CEO of Vitality Unlimited, a Nevada-based corporation, for 15 years. I've worked for Vitality Unlimited for over 40 years. I happen to be here for Behavioral Health Day, and I'm glad to have the opportunity to speak to this bill. Vitality Unlimited offers comprehensive substance use disorder and mental health treatment from our ASAM 3.5 residential treatment facilities in Elko, Carson City, and our CCBHCs in Elko, Carson, Reno, and Dayton. We serve the specialty court in Elko with peer, detoxification, residential, and transitional services. We have been engaged in jail and court diversion programs for many years, and for all individuals who participate, we believe we've had a positive impact. However, I support Senate Bill 17 because it recognizes that substance use disorder is a chronic, relapsing disease. People do recover. I have seen that in the many years that we've served this population, and that for many, it will require more than one experience with residential treatment and ongoing outpatient treatment to bring that person into long-term recovery. A second or third experience with treatment is certainly going to do that individual in our communities more good than spending that time and more incarcerated. Thank you for this opportunity to share our experience in this work.
Is your microphone on? It's okay. There's a little button down on the table that you have to press. Looks like a sticker. It'll turn bright red. There you go.
It is. For the record, Grant Denton. I'm in support of SB 17 because I am a product of diversionary court. I spent 10 years in and out of the system, addicted to heroin and meth. I was homeless the whole time. And, you know, I didn't plan anything. I just heard this was happening. I'm like, what? This is incredible. This is absolutely necessary. We need more of this. And part of the gig is that a lot of times I would I'd go to jail because I didn't have a source of income, but I had this habit that I had to support, and I had to do things, and sometimes I broke the law. I wasn't a bad person, but I was driven to do this because of my addiction. And a lot of times I would get locked up. I would go through the process, right? You get locked up because you do something stupid, and then when you're in jail, your head clears a little bit. You start to understand your role and how you got to where you're at, and then you start to believe that and be optimistic. Like, maybe I can do something. I can get my kids back. I can get a job. I can do this and do that. And then when you're released back into the same world that got you there. And then you identify that since I've been here for 10 years doing this, I don't just have a drug problem. I have an identity crisis. I don't remember how to be an adult, and I don't remember how to do the things, even if I did it at one time. And so we're not in the business of just stopping doing drugs. We have to reinvent people. And part of when I was sentenced to rehab, and I was sentenced to drug court in Vegas, and I was in there for a year, and it was really strict and really rigid, but that's absolutely what I needed. I needed to find out who I was. I needed enough time to gain a new identity by not just learning my weaknesses, but also learning my strengths, learning structure through sober living, learning to show up somewhere on time, which was very foreign to me. So I swear by drug courts and diversionary court. I think they're absolutely necessary. And today I'm the founder of a nonprofit that operates a shelter. We do outreach. We operate the resource center. We're called the Karma Box Project. And if it wasn't for a diversionary court, I wouldn't be here today. My sons wouldn't have a dad. My mom wouldn't have her son back. So, thank you.
Good afternoon. Paloma Guerrero, P-A-L-O-M-A-G-U-E-R-E-R-O, Clark County Public Defender's Office. Every day we see people who made one mistake and that face lifelong consequences that affect their jobs, housing, and families. Diversion programs work because they hold people accountable while also addressing the underlying issue, whether it's substance abuse, mental health issues, or economic hardship. Expanding eligibility means giving more people the opportunity to turn their lives around instead of locking them up into a cycle of crime and incarceration. We've heard of a concern that people will somehow game the system by sealing their records just so they can re-qualify for the program. But sealing a criminal record is not easy. It's a long, complicated process that can take months or even a year, and it's far from automatic. People seek to seal their records so they can get jobs, housing, and stability, not so they can commit more crimes. If anything, the fact that people are desperate to clear their records shows just how damaging a criminal conviction can be and why diversion is so necessary in the first place. This bill focuses on what actually works, which is giving people a real chance of rehabilitation. Expanding pre-prosecution diversion means fewer people cycling through our courtrooms, lower recidivism rates, and safer communities. It's a smart, evidence-based approach to justice that prioritizes both accountability and second chances. We strongly support this bill. Thank you.
Good afternoon. My name is Jennifer Rains, and I'm a Chief Deputy with the Washoe County Public Defender's Office. The perspective that I want to highlight is to supplement the written materials that our office provided as an exhibit through my colleague Angela Knott, to highlight how this particular bill falls within the sequential intercept model that Washoe County has devoted extensive resources to supporting. It's a collaborative partnership in our community with the District Attorney's Office, the Public Defender's Office, law enforcement, the courts. We have all worked closely in order to adopt the sequential intercept model in Washoe County. This fits squarely in Intercept 3 regarding the courts and specialty court to allow more access, as you've heard from testimony earlier today, which in turn leads to healthier humans, safer communities, and tremendous cost savings. And we've already been using many of these ideas to try new projects in our community in order to achieve those goals.
Good afternoon, Chair Scheibel, members of the committee. For the record, my name is Cadence Matijevich, Cadencematijevich, and I'm the Government Affairs Liaison for Washoe County. Ms. Rains, I think we had to trade off because we were going to steal each other's thunder. She just gave you a great description of the sequential intercept model, the SIM. We believe, as she said, in our community, across the community, both at the county level and with our community partners, there's been extensive work in doing and implementing the SIM in our community, and we're already seeing good benefits from it. We expect to see many more to come. Senate Bill 17 directly aligns with the initiatives in the SIM, and so we'd like to thank the court for bringing it, for Judge Birchie for her great explanation of why it's so beneficial, and we urge your support.
Thank you so much to everybody who gave their testimony down here or up here in Carson City. I don't see anybody in Las Vegas coming to the table to give in-person support testimony, so we'll go to the phones for support testimony.
Thank you, Chair. If you would like to offer testimony in support of SB 17, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 963. Please press star 6 to unmute yourself. You are unmuted and may begin.
Can you hear me? Hello?
We can hear you. Go ahead.
We can hear you.
Oh, okay. Sorry. Hello, members of the committee. My name is Yesenia Moya, Yesenia, and I'm speaking in strong support of SB 17, expanding access to diversion programs for folks struggling with substance use is a community-centered approach that prioritizes healing over punishment. Our people currently face immense hardships, poverty, lack of healthcare access, unstable housing, and many systemic barriers that make it nearly impossible to break free from the cycles of criminalization and oftentimes substance use. People are excluded from these diversion programs due to past convictions or prior participation, and SB 17 removes these unnecessary barriers. It empowers our courts at all levels to establish treatment programs and gives judges the flexibility to refer individuals to assessment and support. We have to recognize that substance use is a public health issue, and many people struggle to meet court requirements due to these barriers that I mentioned, lack of transportation, family responsibilities. But these diversionary programs really do help folks really stay on track. Incarceration does not address the root causes of addiction, but a community-based treatment and support programs do. These diversionary programs keep families together, they reduce recidivism, they ease the burden on our courts and our jails, and save taxpayer dollars. More importantly, they give people a real chance to heal, rebuild, and contribute positively to our communities. SB 17 is a step forward and to build a more compassionate system that acknowledges real struggles that our people face, and I urge your support. Thank you.
There are no further callers to offer support testimony at this time.
Thank you so much. We'll move to opposition testimony on SB 17. To testify in opposition, please come on down and take these seats in the front in Carson City, and go ahead whenever you're ready.
Thank you, Chair Scheibel, members of the Senate Judiciary Committee. My name is John Jones, here on behalf of the Nevada District Attorneys Association. And it is my first time testifying in this committee this session, so it is a pleasure to be here. And just a brief bit about the Nevada District Attorneys Association. We include the Clark County DA's office, the Washoe County DA's office, and the other 15 district attorneys' offices throughout the state of Nevada. And I am here in opposition specifically to Section 1 of SB 17. And you've heard a lot of testimony this afternoon about how great specialty courts are. And I can tell you unequivocally, DAs agree. Specialty courts are great, but we have conflated different types of specialty courts. We strongly support post-adjudication specialty courts, where a defendant has either been found guilty or pled guilty, and then as a condition of that sentence, been assigned to one of these courts. Our issue with Section 1 is that it's pre-prosecution, meaning that if a person fails that court, they're then sent back for the prosecution to start at the very beginning. In other words, we don't have a plea to fall back on. So periods of time have passed, and the case is basically stagnant, and that's our issue. There's three main points that I want to address today. First, is that this bill is an unconstitutional incursion on an executive branch function. That being that it hinders our prosecution of a case. Our second point is that it's too expansive, and our third, that I just referenced, is that it delays the adjudication of a case. With respect to the incursion to an executive branch function, I want to cite to you State versus the 2nd Judicial District, in which the Nevada Supreme Court held in part that a court's sentencing discretion, once granted, cannot be conditioned on what was called a prosecutorial veto. The court based this decision on separation of powers principles. And applying those same separation of powers principles, courts cannot infringe upon a prosecutor's right to fulfill their statutory obligation to prosecute a case and seek a conviction. Generally speaking, whether to seek a conviction and on what offenses is an executive prosecutorial function. Secondly, I want to point out that this is an extremely broad statute. And I know Judge Birchie indicated that she's just using the guidelines of SB 222 that passed last session and applying them to pre-prosecution. But my argument is they are entirely different programs. A pre-prosecution is generally meant for a first-time offender. It is not meant for somebody who is deeper into the system. My second point is that this statute allows those charged with stalking, with violations of TPO, temporary protective orders, all to be eligible for pre-prosecution. Those are inappropriate offenses and should not be subject to pre-prosecution. My third argument is that it delays adjudication. I always like to say cases are not like fine wine. They do not get better with age. And the pre-prosecution program allows a defendant up to 18 months in the pre-prosecution program. At that point, the judge says, you failed, you go back to step one. So now I've got a misdemeanor case that is over 18 months old, and I'm supposed to prosecute that. Cases are not like fine wine. I want to end with a reference to Marsy's Law. The Constitution of Nevada provides victims with the right, and I quote, to the timely disposition of the cases following the arrest of the defendant. Section 1 of SB 17 violates that provision. With that, Chair Scheibel, I am happy to answer any questions. Again, I do want to point out my issue is not with specialty courts, it's with an expansion of the pre-prosecution specialty court outlined in Section 1. Thank you.
Thank you. Hold on one second. I don't see anybody coming to the table in Las Vegas, so I will, since you offered, open it up for questions to the members of the committee. I don't see anybody else with questions. I just want to clarify the position of the District Attorneys Association. I completely understand what you're saying about the difference between treatment court and pre-prosecution diversion and wanting to not expand pre-prosecution diversion. Would the District Attorneys Association actually prefer to eliminate pre-prosecution diversion programs?
John Jones on behalf of the Nevada District Attorneys Association. I can tell you, Chair Seibel, we did oppose putting in this statute to begin with, so we were opposed then. That being said, I can tell you that pursuant to our executive function, that some of our offices do in fact have pre-prosecution programs. My office, the Clark County DA's office, does have one. But that is an executive making an executive decision about what to do with that case. It's not being told what to do with that case by the judiciary.
Understood. Thank you. I don't see any other questions, so we appreciate you providing your testimony today. And it looks like we do have some more opposition testimony. Please go ahead whenever you're ready.
Good afternoon. Jason Woodard, JASON WOODARD. Madam Chair, members of the committee, I represent Nevada Sheriffs and Chiefs Association. This is also my first time testifying in front of this committee. Allow me to describe the Nevada Sheriffs and Chiefs Association. We represent police executives of all of the different police agencies throughout the state of Nevada. I'm here today in opposition of SB 17. We would like to echo the sentiments brought forward by the Nevada District Attorneys Association, specifically our concerns about the broadness and the limitation of the prosecutor's ability to make proactive decisions in the prosecution of cases. We are in support of diversion programs. However, the two issues previously listed are our concerns. Thank you.
Thank you. Okay, at this time, I don't see anybody else coming forward to give in-person opposition testimony in either Carson City or Las Vegas. So we will go to the phones for opposition testimony on SB 17.
Thank you, Chair. The public lines are open and working. However, there are no callers to offer opposition testimony at this time.
All right, then, we will go to neutral testimony. Anybody wishing to give testimony in the neutral position is invited to the front of the room in Carson City or Las Vegas to do so now. I don't see anybody making their way to the front tables, so we'll go to the phones for neutral testimony on SB 17.
Thank you. There are no callers to offer neutral testimony at this time.
All right, that concludes testimony on SB 17. If the presenters have any closing remarks, we can take those now, but looks like we have someone coming down here to give some closing remarks on SB 17. Thank you.
Kendra Birchie for the record. Thank you again for the opportunity to present this bill. As you heard, specialty courts, whether that's pre-prosecution diversion, through diversion, or as a condition of probation, save lives. They allow people to be able to return back to their community, to work. Sometimes they have the first job that they've ever been able to hold, to reunify with their family, and to be productive members of our society. With respect to some of the opposition that we heard, I'll just note again that with points 1 and 3, those are not issues that this bill has changed. That is what's currently in statute. And so we did not modify this bill to change the procedure of having someone come into and request a pre-prosecution diversion. Marcy's law still applies, those statutes still apply, so we did not change or any modification regarding the actual procedure to make the request. With respect to who is eligible, I know that we have indicated we're willing to work with those in opposition. I'll just make sure that's clear on the record to continue. We're willing to continue to work. The goal is to make sure that we are able to assist more individuals as quickly as possible to help deflect them from the criminal justice system for those who are deserving and who are appropriate. Thank you.
Thank you so much. And that brings us to the conclusion of our hearing on SB 17. I will close that hearing and open the hearing on SB 20 and invite Mr. McCormick back down to the front table along with a possible, no co-presenters, possible question answerers. Okay, go ahead whenever you're ready on SB 20.
Thank you, Chair. Again, my name is John McCormick, Assistant Court Administrator at the AOC. And SB 20 is primarily intended to provide cleanup regarding the conduct of preliminary hearings for gross misdemeanors and felonies in justice court. We understand there is some opposition to Section 3 that deals with what we refer to as dangling misdemeanors, which are those misdemeanors that are charged on the same information or indictment with more serious charges, and we hope that we can continue to work with interested parties to see if we can arrive at a statutory mechanism that will address this issue without creating any potential unintended consequences. Section 1 of the bill provides that if a defendant is advised on the record that a waiver of preliminary hearing is unconditional or affirms that fact in a written waiver, that the case may not be returned to justice court for further proceedings and the case is under the exclusive jurisdiction of the district court. Section 2 eliminates the requirement that a preliminary hearing for a potential death penalty case be reported by a court reporter and rather allows the court to record such a hearing through the use of audiovisual recording equipment, which is in fact the same as every other proceeding in Nevada trial courts, except for the part we're going to talk about in Section 4 right now. However, I do want to reiterate that currently a murder trial, high dollar civil trial, any of that can be recorded utilizing audiovisual means. The only proceeding where there is a statutory requirement for a court reporter is that preliminary hearing on a potential death case. So we're just seeking to eliminate that requirement so those preliminary hearings can be recorded through our normal AV recording methods. This section is also where you will see the friendly amendment that was provided to the committee by the Nevada Judges of Limited Jurisdiction. And this is an amendment that seeks to further clarify what happens after we've recorded one of those preliminary hearings, and it provides that a court, upon request of one of the parties or the district court before the trial in district court, may designate a person who is not a certified court reporter to generate the transcript of the audio recording of the preliminary hearing. And the amendment also clarifies the retention period for that sound recording of a preliminary hearing to be 5 years. And we, as I indicated, that amendment is considered friendly. Section 3 is the section of the bill that I referenced earlier that is intended to require that misdemeanors charged in the same information or indictment along with gross misdemeanors and felonies to be disposed of in district court. A number of concerns have been brought up, and you will probably hear a few of them later on this. And we want to continue to have discussions with interested parties as well as within the judicial branch to see if we can arrive at language that will address the issue of dangling misdemeanors without creating additional concerns. So again, we would ask the committee's indulgence to continue working on that section. Section 4 updates a 1967 statute that requires a court reporter for jury trials in justice court. This requirement lay dormant for many years, specifically from 1989 until 2019. In 1989, the Nevada Supreme Court and then subsequently the United States Supreme Court decided a case called Blanton versus North Las Vegas, which said you didn't have to have a jury trial if the penalties for the offense were de minimis, basically. So between 89, when that decision happened, and 2019, when the Nevada Supreme Court decided Anderson versus 8th Judicial District Court, this was not something that we were particularly concerned about. It was kind of a, whatever, it's still on the books, but okay statute, for lack of a better term. However, as I indicated, when the Nevada Supreme Court decided Anderson versus 8th, they determined that the consequences, particularly with regard to firearm rights that attach upon a domestic violence conviction, were no longer de minimis, and thus jury trials were required for domestic violence matters at the limited jurisdiction level, at the misdemeanor level. So that is where we are now. So then we have this statute from 1967 that indicates a court reporter has to report these proceedings, not a standard AV means as we currently use for most things. I mean, it depends on the courtroom too. Some judges prefer a court reporter, some, you know, like the AV recording. But the situation that we're trying to avoid by removing this provision is best illustrated from sort of a situation I was made aware of this summer. I had a judge in a rural jurisdiction who had, who had scheduled a misdemeanor domestic violence trial and absolutely could not find a court reporter. I mean, the court called everybody in the world, not being hyperbolic, obviously, but called everybody they could. They couldn't find a court reporter. So the judge was put in the situation of, do I follow this statute requiring a court reporter, or do I honor the defendant's right to a speedy trial? And so what we're trying to do here is clean that up, because court reporting is a profession that unfortunately a lot of people are not entering anymore. And so court reporters are becoming fewer and farther between. And so it's becoming more and more difficult for courts to secure a court reporter for these matters, particularly a rural jurisdiction having, maybe the one domestic violence jury trial it's had in the last 2 years to get that reporter. So again, that's why we want to remove that provision, just to ensure that court proceedings are obviously recorded appropriately, but we no longer are in a position of potentially fighting between the statute and the Sixth Amendment, for lack, to be fairly simple in that. Excuse me. And finally, in this bill, in Section 5, that is a clarifying section that just reiterates that municipal courts have jurisdiction over misdemeanors committed within those the city limits of the incorporated municipality in which they serve. So those misdemeanors must be adjudicated there. So that is, again, a clarifying section. As I indicated, the potential or the primary focus of this is to just sort of clean up those preliminary hearings and attempt to improve efficiencies and how the process works. Happy to answer any questions on this. Thank you.
All right, thank you so much for presenting the bill. Questions from members of the committee. I will start with Senator Wynn.
Can I just, what is the, I'm still not gathering what the, why this is necessary outside of the court reporter, court recorder, sections of the bill. I guess have some questions about the other sections of the bill, like the misdemeanor.
Thank you, John McCormick for the record. In terms of what I refer to as dangling misdemeanors, what'll happen is it's charged on one information or indictment, so you have a misdemeanor and, say, a felony together, right? So the felony goes up to district court, and then we end up having this misdemeanor that's just kind of hanging out over here. And then say the defendant is convicted at the district court level and is sent to prison, then we're not necessarily going to adjudicate the misdemeanor, but we have this misdemeanor charge at the justice court level that is just kind of hanging out and can't be disposed. So the idea that we're trying to get at is addressing that issue to make sure that all the charges on the indictment are adequately disposed. As I indicated, we've had some concerns on that about the misdemeanor going up to district court and then how that would play out there. So we would hope to continue to engage in those conversations. But the idea is to not have these sort of misdemeanors just languishing while the more serious criminal proceeding occurs at the district court level.
I mean, but aren't there court dates that are set in a status check so you can handle these things? Like in my experience, if you had that dangling misdemeanor, so part of the case, the felony case went up to the district court, the misdemeanor case was set over into the justice court, you would have a status check to see what the resolution was, and
there would always be an existing court date down in the justice court to continue to handle this. Is this just merely convenience of not wanting to have two courtrooms that the cases are handled in?
Thank you for the record, John McCormick. That is not my understanding of what we were desirous of here, and I believe there are some differences in practice across jurisdictions in the state where perhaps some of those misdemeanors are being adjudicated in some jurisdictions and then otherwise they're being filed and then not pushed forward or prosecuted, and so they end up dangling and hanging out there.
Well, wouldn't that be up to the prosecution to either decide to dismiss that case if someone is perhaps headed to prison on a felony charge?
John McCormick, for the record, I would think that is a potential solution, yes.
Oh, okay. Chair, may I ask another follow-up question? In this scenario with these changes as proposed in Senate Bill 20, one of the things that I also have concerns with is any of these cases that potentially start off as felonies that are later like plea bargained or reduced down to a simple misdemeanor. Do we want to put these district court judges? I know that some of these amendments were proposed by the courts of limited jurisdiction, but do the district courts, they are definitely not in a position to monitor simple misdemeanor cases if they're resolved. So I know in the current way it stands is like a misdemeanor, if it's resolved to a simple misdemeanor, any of the collection of fines or community service, or any counseling requirements are in a better probably position to be monitored by those courts of limited jurisdiction. And under this scenario, we now have district court judges that are handling serious felony cases that are now like pseudo status check judges on these requirements. Will this add an added burden to those district courts when they can no longer send these cases down to be adjudicated in the justice courts?
John McCormick, for the record, that is one of the concerns that has been raised and that we are currently discussing regarding this bill, because there is a potential for that. As I indicated, I think there is some work to do, particularly on that Section 3.
Okay. I have some concerns that we are adding an increasing workload onto a new district court, onto the district courts, when clearly the justice courts are better equipped to handle those kind of misdemeanor charges. I think that would be like my concern with those provisions of the bill. Chair, may I ask one last question? When we're talking about also the ability to have these cases stay with each other, so back to that dangling, I realize the problem that I think you're trying to solve. I maybe disagree that it's an actual problem. But with these dangling misdemeanors, could you have a situation where someone is going to have a misdemeanor trial, and on the eve of the trial, the prosecution amends to add a gross misdemeanor or a felony in order to bind it up to district court, and then can later resolve that case and you're still stuck in the district court? So I just have some serious concerns about that Section 11 and also that first section on what kind of burden. It just seems like you're shifting the work to a different court. But thank you. And thank you, Chair, for the questions and the indulgence.
Okay, we'll go to Senator Ellison next.
And I think maybe you hit on this really well. But the question that I was wondering is, if you had, say, a couple misdemeanor trials that was pending, and then you had a felony, and they go to district court for the felony in charge and go to prison, could they still use the gross misdemeanor or the other trials that goes to justice court? Can them be hanging on if they did any violations after they got out? Or does the statute of limitations step in and say, no, you can't do that?
Thank you for the question. My name is John McCormick. The statute of limitation for prosecution of a misdemeanor is 1 year, so we would get sort of sideways, I think, with some of those time periods. Yes, sir.
Thank you. I'm just going to chime in here, though, but wouldn't the charge have already been filed within the 1 year statute of limitations? So you wouldn't run afoul of the statute. You would just be having a misdemeanor trial on a battery charge that was associated with a robbery with use. 10 years after the person gets out of prison on the robbery with use, you'd go back down to district court to have your trial on the battery charge.
Thank you, Chair. Yeah, John McCormick for the record. You are correct, yeah.
Okay. Other questions from members of the committee? Senator Orenshaw.
Thank you, Chair. And Mr. McCormick, my question on Section 2, the deletion of the requirement for a court reporter in a capital case at the preliminary hearing. I understand the difficulty finding court reporters, but I'm just wondering if the AOC has taken the temperature of prosecutors and defense attorneys who handle capital cases, just to see, since there's so lengthy appeals in these cases, where the prosecutors and defense attorneys feel about this deletion of that requirement. I'm just wondering if, that's something that, even though it might be difficult, maybe that's something that might need to be retained. I'm wondering if you've heard from those attorneys that handle these capital cases.
John McCormick for the record. I have discussed various aspects of the bill with both public defenders and district attorneys, and nobody has brought that up as a concern. The concerns were more along the lines of Senator Wynn's concerns.
Thank you, Chair.
Thank you. Any other questions from members of the committee? All right, I don't see any other questions. Thank you so much. We will move on to testimony. I just want to point out that I understand there are still possibly forthcoming amendments on Section 3, and so I imagine that the disposition of those amendments is going to affect where people would testify on this bill. So to make things simple, I'll go ahead and have you guys testify in the position you're currently in, but if you could address each person who testifies, whether you're open to resolving the issues with Section 3 or there's nothing that can be done, I think that would be helpful for my committee in making a decision. And with that, I will invite testimony in support of SB 20 here in Carson City and down in Las Vegas. And just take a seat here in the front, and whenever you're ready, please limit your comments to about 2 minutes.
Kendra Birchie for the record. I am appearing on behalf of the Nevada Judges of Limited Jurisdiction. As a member of the Justice of the Peace for Reno Justice Court, I am also a member of that committee. And so I want to thank the AOC for being willing to work with us with respect to the amendment. And so I am in support, and I'll just, based off of the chair's information, we are willing to also work and would be in agreement to modifying that other section as discussed. Thank you.
Thank you. I don't see anybody else coming down to give support testimony on SB 20, so we'll go to the phones for testimony in support of SB 20.
Thank you, Chair. The public lines are open and working. However, there were no callers to offer support testimony at this time.
All right, then we will go to testimony from people who are in opposition to the bill as currently written, and invite you to make your comments in person here in Las Vegas or here in Carson City or down in Las Vegas now.
Thank you, Chair Scheibel, members of the Senate Judiciary Committee. My name is John Jones, and I'm here on behalf of the Nevada District Attorneys Association. We are in opposition to SB 20, specifically Section 3. And I will say, Chair Scheibel, I don't know if there's any language that's out there that we can agree to with respect to Section 3. I will say, in January, we met with John McCormick, and we sincerely appreciate him taking the time to meet with us about the bill. And Ms. Noble, who represents the Washoe County DA's office, and I went back to our office to try to think through what a legislative scheme surrounding misdemeanors in district court would look like, and we could not come up with anything. And we had several meetings about this issue, and one reason why I'm here today in opposition is there was nothing that I think alleviated all of the concerns that we have. So we understand that this is meant to tackle a common administrative issue. In my experience, it's a fairly rare occurrence that doesn't cause significant administrative burden on the justice courts. But that being said, I'm not sure there is anything that will alleviate all of our concerns with Section 3. With respect to Section 4, I did receive the proposed amendment from the judges of limited jurisdiction. We are still evaluating it to see if it has any potential implications regarding Senator Orenshaw's question about death penalty cases. I'm specifically thinking about the daily transcript requirement and things like that. So we're still evaluating our position on the new amendment to Section 4. Thank you, Chair Scheibel.
Paloma Guerrero, P-A-L-O-M-A-G-U-E-R-E-R-O, Clark County Public Defender's Office. We concur with the District Attorney's Office. We also don't see a way to propose any new language for Section 3. With the other parts of the bill, we're totally fine with. We did reach out to our murder team and our attorneys that would be in those courtrooms, and they didn't have any problems with the recording parts of this bill. But as far as those dangling misdemeanors in Clark County, it's not really an issue. As explained, the case gets bifurcated and the misdemeanors get placed in justice court, and then there's just status checks to keep track of what happens with that misdemeanor. So this problem has a very simple solution, and I think Clark County solves it pretty well. And this proposed solution is very problematic from our perspective. We want the justice courts to keep the jurisdiction of those misdemeanors, so they're the experts on misdemeanors. And we also worked very well with Mr. McCormick, and we thank him for always being open to these conversations. Thank you.
Good afternoon, Angela Knott from the Washoe County Public Defender's Office, ANGELA KNOTT. Today we are opposing SB 20 for two reasons. One would be that first section regarding negotiations and the conditional and unconditional waivers. Typically, most plea negotiations are conditional waivers, where we waive the preliminary examination, they go up to district court, sometimes plea negotiations fall apart, but we actually already have a statute for when that happens. That's NRS 171.208, and that's up for the discretion of the district court to determine if there's good cause to remand the case back down to the justice court. As written currently with SB 20, there is a concern that the justice court could just make all waivers unconditional. I'm not sure how that would happen, but that is something that we have concerns on going forward. Making all waivers unconditional could have negative consequences on our plea negotiations, and it could remove the discretion of the district courts. The other section is regarding Senator Orenshaw's question with the death penalty cases. We have some issues with the Supreme Court Rule 250, currently requires daily transcripts, usually for trials or post-conviction hearings. But I believe that when we're doing preliminary hearings with a death penalty case, you're going to want the daily transcripts. I'm not sure the justice courts would be able to handle preparing daily transcripts if we use audio only. I think JAVs would be important so that we can actually see the faces of the witnesses. And the other concern is sometimes there might be, a witness might misspeak or you don't understand what they're saying. With a court reporter, they can simply ask for clarification and it gets fixed on the record. But if you only have an audio, you might not know until later that evening or the next day that you don't understand what's actually on the audio. And there's no way to fix that. The transcripts from the preliminary hearings are important when you're cross-examining any witness at a trial, especially a death penalty trial. So for those reasons, we're opposed to SB 20. As far as the Section 3, we are neutral currently, and I think we want to wait to see what the amendments are going to be. Thank you.
Thank you. And I do have a question for your office. You don't have to answer it right now. It's a take back to your office and let me know question. I read section 1 not to really change the conditional or unconditional nature of the waiver, but just to allow for it to be in writing. And so I would be interested to know if your office has a problem with that aspect of it, or if you're fine with it being in writing, you just want to make sure that you retain your current scheme for conditional versus unconditional waivers. All right, and with that, we'll open it up for any additional opposition testimony on SB 20. I don't see anybody coming forward, so we'll go to the phones, please, for opposition on SB 20.
Thank you, Chair. The public lines are open and working. However, there are no callers to provide opposition testimony at this time.
Okay, then we will go to neutral testimony on SB 20. Anybody wishing to give neutral testimony in person is invited to do so now. But I don't see anybody coming to the table to give neutral testimony. So instead, we will go to the phones for neutral testimony on SB 20.
Thank you. There are no callers to provide neutral testimony at this time.
All right, thank you so much. That brings us to the conclusion of testimony on SB 20, and I will invite our presenter down to give closing remarks on SB 20.
Thank you, Chair. John McCormick for the record. Just quickly, I don't know of any court in the state that currently only does audio recording. It's all AV. Generally, as the Washoe County Public Defender's Office said, a lot of courts use JAVS, Jefferson Audio Visual Systems, which is a specific audio-visual recording solution designed for use in court. So I don't believe we're going to end up in a situation where it would be an audio recording only. And then also, I just wanted to brag that in addition to the shortest bill presentation before this committee, I got the Clark County DA and PD to agree. I mean, they're opposing the bill, but they agree.
I agree, Mr. McCormick. I think that was a noteworthy accomplishment, and your accomplishment will be recognized. And with that, I'll close the hearing on SB 20, and we will go to the next item on our agenda, which today is the possible introduction of BDRs. For the first time this session, we do have a BDR to introduce. All of the members of the committee have been provided with BDR 5-493. Just like any bill, a committee bill starts with the request, and the bill draft request is the language of the proposed bill. By reviewing this, the committee has a decision to make about whether or not we would like to introduce the bill that is proposed within the bill draft. The vote that the committee will be taking, if there is a motion to introduce the BDR, would be a vote simply to introduce the bill. It doesn't change whether or not you support the bill. You can change your mind about that. There will still be plenty of discussions on it. But whether this BDR gets to grow up and become a bill is up to us today. We did hand this out at around the beginning of the meeting. It's about 6 pages long, but now would be the time if the members have any questions about the bill draft request.
Madam Chair, not a question, but I would like to move for the introduction of BDR 5-493.
Thank you. We have a motion from Vice Chair Flores. We have a second from Vice Chair Orenshaw. From Senator Orenshaw, who we appreciate. And any discussion on the motion? All right, seeing no discussion, we'll do this by a voice vote, and we can go to a roll call if necessary. All in favor say aye.
Aye.
Any opposed, nay. Like I thought, that roll call vote is not necessary. By unanimous vote, we will introduce BDR 5-493. And that, I believe, brings us to our final item on the agenda for the day, which is public comment. Anybody wishing to give public comment in person is invited to do that now in the front of the room in Las Vegas or Carson City. Not seeing anybody coming to the table, we will go to the phones for public comment, please.
Thank you, Chair. The public lines are open and working. However, there are no callers to provide public comment at this time.
All right, then that brings us to the conclusion of our meeting. We will be meeting at the same time, same place tomorrow. And until then, we are adjourned.